Back row.
When it rains, it pours, and this is definitely. All right, who do we have, please?
This is going to be position number 6, Mr. Rawls.
All right,
Hello.
Brandon Rawls. Who represents Brandon Rawls?
I do, Your Honor.
No problems, right?
No
I'm
issues.
going to start from the beginning. All right. Brandon Rawls has got a case 23 CR 4517E, accused of battery, domestic violence from July 19, 2023. Mr. Rawls, my name is Judge Lal, and I want to remind you that you have a right to remain silent. Anything you choose to say during this recorded proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kelly Wills. And Mr. Howard?
First.
Okay. And Mr. Jones, good afternoon.
Good afternoon, Your Honor. So this incident took place on July 19th, 2023, where officers were dispatched to 394 McDonald Boulevard to a dispute call. Upon arrival, officers met with Ms. Lauren Rawls, who stated that she had just gotten to a fight with her husband, the accused, Mr. Brandon Rawls. She stated that the accused arranged to meet up at his home to discuss divorce arrangements. Things got heated, and the defendant snatched her phone out of her hand and proceeded to look through it. The victim, attempting to regain control of her property, the accused then strong-armed her and pushed her into the side of the home. Filled with anger, he then busted her lower lip by striking her with his left elbow.
What do you recommend for bond? I'm sorry, but I've already read that portion already.
Yes, Your Honor. So we had an opportunity to speak with our victim, and she did inform us that she is afraid of this defendant, and that she does not want any physical contact with her. She did believe that at the time when the defendant got in the car, he was going to run her over. And the defendant also fled the location after the incident took place, which also makes him a threat, Your Honor. Therefore, the state's recommendation is going to be a $3,500 surety bond and no further contact with Ms. Lauren Rawls. She is open for a third party transfer, and she has asked for a one-time law enforcement escort for him to come and get his items out of the house.
Okay.
And when you're we like to sign for the victim, she is
I was just about to. I do see Miss Lauren Rawls on the Zoom. Miss Rawls, my name is Judge Law. If you would like to contribute to this hearing, you need to start your video and unmute your Zoom. All right. Miss Rawls, you will need to remove your hat. You're in a courtroom. Thank you. All right. Would you like to add to these proceedings, or you can choose to remain silent?
My only other concern.
Then you will need to be placed under oath. Do you solemnly swear and affirm? Please raise your right hand. Swear and affirm that the testimony you provide will be the truth to the best of your knowledge.
Yes.
All right. So you are open to the third party transfer of, so a third party would have to step in to pick up your child or children and have visitation with Mr. Rawls. You're open to that idea?
Yes.
And who would you be selecting as a third party?
We have someone that lives in our unit upstairs. His name is DJ.
Is that all you know about this person?
What do you mean? Is that all that I know? He's our trustee, our family trustee.
Okay, DJ what? What's the name?
Asante.
Full name again, please.
DJ.
All right.
Asante. ASANTE.
TE. Okay, just wanted to be sure who this person is. Are you comfortable with Mr. Rawls being in your home?
No.
All right, that's good for me. Thank you. Miss Wills?
Thank you, Your Honor. My client is 35 years old. As it was stated, this is his first arrest. He has relocated and is no longer living in the marital home. He and Ms. Rawls are going through a divorce, and they were in the process of working that out, the logistics of their separation prior to this incident occurring. My client does deny making any physical contact with my client. With Ms. Rawls purposefully or intentionally. He did take her phone, which revealed that she was there was some infidelity. She, in her attempt to take the phone back, she struck my client several times and he suffered multiple injuries. He left the scene because it had escalated to a point where he was uncomfortable and had been physically attacked. He did not flee the scene. I do not hear or did not hear any evidence of any risk of reoffense necessarily, or intimidation. My client has a vested interest in seeing his 3 children who are 10, 7, and 4. And so we have no objection to him staying away from the home at this time or not having contact with Ms. Rawls at this time. But I would request a signature bond, given that this is my client's first arrest. It was noted that Ms. Rawls suffered a busted lip. I didn't see any evidence of that. And this incident just occurred recently. So for all of those reasons, I think a signature bond is appropriate in this case.
Bond is set at $7,500. It's going to be a signature bond through pretrial services. Mr. Rawls, is a rather high bond amount, but right now it's a signature bond. You will be required to report to pretrial services once a month. If you get arrested again for anything else, that signature bond will be revoked and converted to a surety bond or a cash bond. While you are out on a signature bond, you are to attend and complete a 6-month or a 24-week domestic violence program. You must show proof that you have enrolled in such a program within 60 days of being released on your bond. You are to provide us with you are not to return to the address at 394 McDonough Boulevard in Southeast Atlanta, and you are to have no contact with Miss Lauren Rawls. That's Lauren. I understand that you both share about 3 children together. So any visitation will have to be done through a third party. And right now it appears to be a Mr. DJ Asante who would facilitate the pickup and drop off of the children in question based upon a schedule that has to be mutually arranged with Mrs. Rawls, but only through Mr. Asante. Do you understand, sir? All right. No consumption of alcohol, no illegal drugs, and you're not allowed to own or possess a firearm or weapon. Ms. Rawls, if you are in further concern about your safety, you can also file a petition for a TPO with the Superior Court of Fulton County, and that would just be a double protection.
Okay.
All right. All right. Thank you. His next court date is going to be sent to his new address, so he needs to update the court with his new address within 30 days.
That's per judge.
Mhm.
Okay. All right. I told you that.
All right, we got number 1, Mr. Bradley.
Okay,
And he has refused representation by counsel.
all right. This is 23 CR 004409G, Richard Bradley.
I'm sorry. Can you repeat that?
Who's speaking? Mr. Bradley?
I am now, Your Honor.
All right, can you're not speaking?
I
That wasn't him.
Oh, that wasn't him.
No.
Okay. All right, you're charged with 1 count of simple battery, family violence, 2nd count of willful obstruction of a law enforcement officer, 3rd count of criminal trespass, pretrial.
4th arrest, last arrest was last month. Death by taking in out of South Fulton. Before that was 1999 larceny conviction. That's it.
Okay.
Your Honor.
Yeah. I'm sorry.
I don't understand the charges. You said something about trespass. I wasn't made aware of that.
Criminal trespass. I don't know if the charge was added by the state once they accused the case or not, but I do have 3 charges.
Can you repeat those 3, please?
Simple battery, family violence, willful obstruction, a law enforcement officer, and criminal trespass. All right, go ahead, state.
Judge, good afternoon. My name is Brian Pilon. I'm presenting for the state. Officers responded to the location at 1:30 a.m. yesterday morning, so about 36 hours ago. The victim in this case told officers that she and the defendant got into a physical altercation. It was initiated by the defendant attempting to take her phone. The defendant eventually did take her phone and ran into the wood line behind their home. When the defendant returned to the home, he re-entered the home against the officer's command, then refused to come out of the home when the officers commanded such, and barricaded the door with a washing machine. My understanding is the victim is present on Zoom. She alleges that the defendant has been abusive over the course of their marriage. She does not want further contact and does not want him in the marital home. Just to clarify, Judge, the criminal trespass charge comes from the taking of the phone. It is not theft by taking because they are married, but it's criminal trespass because he interferes with her possession and use of the phone.
What's the victim's name?
Victim's name is Miss Anisha Bradley. And I do see her on the call.
So you want there to be, your recommendation is for no further contact. What about a stay away?
Judge, our bond recommendation is a $3,000 surety bond with FVIP, no further contact with Miss Anisha Bradley, and stay away from the address, which I have here is 862 Cascade Crossing Southeast, and that's in South Fulton.
All right. Miss Bradley, Anisha Bradley.
Yes, ma'am.
All right. Do you wish to make a statement to the court today?
Yes, I had a question as far as support for the children, like grocery.
No. This is a bond hearing.
Oh,
Now,
okay.
I can't do all this. This is a bond hearing. And my question is, did you want to make a statement to the court? Tell me yes or no for that first.
No, I don't.
Okay. All right. So you can continue to listen and mute yourself. And all I'm going to rule on today is bond. Okay. Anything beyond that, you'll have to go to a different forum for that. Okay.
Okay. Yes, ma'am.
All right. Go ahead. Who's representing Mr. Bradley?
Pro se, Your Honor.
Oh, I'm sorry. She did tell me that. So you're representing yourself. You
Yes.
understand the consequences of representing yourself?
Yes, ma'am.
Okay, so if you make any statements against your interests, they will be used against you later. I don't recommend you represent yourself. This is a serious criminal proceeding. But if you wish to go ahead with that being the case, I will listen very briefly to you because I'm sure it's going to be interesting. So what is it that you would like to tell the court?
First, I'll be pleading not guilty to all charges. I know we can't get into the details of it, so I won't discuss the details other than to say I never made physical contact or skin contact when I slid the phone out of her back pocket. And then I did not leave the property. The statement's incorrect that I ran into a wood line and I left. I ran into my own backyard where my chicken coop is, and that's where I was. So the phone never left the property. I did not deny the defendant, the complainant use of her phone. I was just trying to go in her phone because she came home intoxicated at the hour that the state mentioned.
Okay, I'm not going to debate the facts with you.
Okay.
Because the warrants have already been taken out. The case has already been accused. So
Right.
how old are you?
I am 43 years old. I'm active duty military. I work in the Sam Nunn Federal Building downtown. I have 8 children. I know she's concerned about groceries. I take care of, my oldest 3 are in college. 2 of them live at home. We have 5 minor children at home. I'm very actively involved in their lives. I don't know what my life will look like if I'm not allowed to come back home. There's no history, even though the state said that there's a history of violence, there is no history of domestic violence. This is all a lie. My wife is trying to take custody of the kids. We're getting ready to go through a divorce. This is a very great effort that she has launched to try and discredit me. I would ask, I'm not a flight risk. I'm a federal employee. I'm active duty military. I really don't have a lot of money because I have 8 children who depend on me. My wife pays 0 bills, even though she has a job. Her money is hers, but I pay 100% of everything. Rent alone is $3,000. And if I can't return to that home, I don't know where I'm going. But I assure you that I'll come to whatever. I want to get this resolved. This has very big implications for me with this, top secret security clearance in the military as a federal employee. This must get resolved. Like I will show up in court. I do not need a bond. If you would release me on a signature, that would be great, Your Honor.
Right?
Me and her both know. And I don't know yet. That's what I gotta wait and see.
Your Honor, I'm having a hard time hearing because there's someone else in the background, but I just wanted to make you aware of just some basic information about the posture of this situation. So the report indicates, and our review indicates, that this married couple intends on filing for divorce, but there has been no filing. There's no actual divorce that's pending or ongoing, no representation that has occurred. They're currently living in the marital home. And the prior instances that we have been told about basically include gathering information and evidence to try to use against each other in some divorce that may happen in the future. So Mr. Bradley had a theft by taking case that was ultimately dismissed based on Judge Law's reading of the law, which she believes says you can't be charged with theft of a piece of marital property. That's why this gentleman's not charged with theft today. He's charged with the interference of the same type of property. But a month ago, it was the same allegation, stealing someone's phone that he happens to be married to, although a phone is usually for someone's exclusive use, like a vehicle, and marital property can certainly be taken and possessed by someone who is not the intended possessor. But that'll be a later date issue for a jury and demurrers potentially. So what we have here is admissions by this gentleman that when he was found hiding under his wife's bed, that he hid under her bed, that he went through her things, that he was intending on having her phone, and he wanted to take her phone so that he could go through it and collect evidence of what he thought was her cheating for some divorce later in the future. So at this point, what it appears to be is that two people living in a rented marital home who have not filed a divorce, but are currently having a difficult time living under the same roof and behaving in an appropriate manner. The police report does indicate children were on scene, adults and minor children. And erroneously, these people were told that they could not take a statement from a minor child, which is not true in a criminal matter. So although a situation like this would usually be one where we would want witnesses' statements about what was going on, that wasn't allowed to happen in this situation. Whether or not Mr. Bradley is employed by the military, or who pays rent and whose money goes to pay bills, those are not factors to consider in bond at this point. But ongoing abuse, a escalating situation, which is what I would describe this as, and admissions by a defendant that he hid under the bed and purposefully was trying to go through the things of his wife to gather evidence against her, lets us know as the state that this is a situation where people need to be separated. And there needs to be an actual cooling off period. So we would specifically request for staying away from the location and no further contact, and for these people to go ahead and file divorce if that's the intention. This is a unsustainable situation to be handled in this manner. Thank you.
All right. Hold on 1 second. Has victim witness advocate spoken to Ms. Bradley?
Absolutely, Your Honor.
All right, I'm going to enter the $3,000 surety bond. I'm going to order that the defendant would stay away from the marital home. There has not been the ample cooling off period. I don't even think it's been 24 hours yet. That is to make sure that the victim and the children are safe and will be safe going forward. I will allow a one-time law enforcement escort to return back to the property with Mr. Bradley to get any personal belongings that he might need. I will also order no further contact with his wife, Anisha Bradley, at this point. If there's visitation allowed with the children, then that should be precipitated, or a third party should be the intermediary with that. The minor children anyway. So find a third party that can help facilitate visitation. No drugs, no alcohol, no weapons, no guns while on bond. And that will be the order of the court at this time.
Judge, can you please give a breakdown of the bond?
State, what was your recommended breakdown?
Judge, I didn't suggest one, but I'd suggest 3,000 on the simple battery family violence.
Okay, well, I've only, the three charges, so I'll do 2,000 on the simple battery and 500 on the other two.
That's
For a
acceptable.
total of-
Thank you, Judge.
Okay, for a total of 3,000. All right, that'll conclude this matter.
Next, we got number 7, Mr. Hughley.
All right, Deputy, which case again?
Number 7.
Okay, 23 CR 004407Y, Rodriguez, Hughley, charged with 1 count of simple battery, family violence, pretrial.
Second arrest, last arrest was for obstruction, possession of a pistol or revolver by a person under 18 years of age. He's out on pretrial bond for that. That's it.
All right.
Yes, Your Honor. So this incident took place on May 2nd of 2023, where officers responded to 3144 Martin Luther King Jr. Drive to an injured persons call. Upon arrival, officers were met with the victim, Miss Micaiah Driggles, and her first name is spelled M-I-C-H-I-A-H. Last name is spelled Driggles, G-R-I-G-G-E-R-S, who advised officers that her baby's father assaulted her. Ms. Driggles said that she had just got home, and the defendant met her at the front door and said, "You might as well put your stuff down because we are about to fight." As she continued to walk into the home, he punched her in the face in the presence of their 7-month-old son, knocking them to the ground and smashing her iPhone 11. She got away, locked herself in the bathroom to call the police, and he fled. Your Honor, for those reasons, and given his criminal history, the state is going to ask for a $3,000 surety bond and a stay away from 3144 Martin Luther King Jr. Drive. I do believe that the victim is on, and if the court can sound for her at the appropriate time.
All right, the victim, do you want to make a statement to the court?
Yes, ma'am, I do.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you in fear of Mr. Hughley?
No, ma'am.
Okay, do you want to have any contact with Mr. Hughley?
Yes, ma'am. We've already, since this incident, we have contact. We still do for our child, and there hasn't been any problems. And also some of the statement or what Mr. Jones said was untrue as well.
Okay. All right. Edie Wills?
Well, if I could ask Miss, is it Driggers? I'm sorry.
Yes, ma'am. It's Micaiah Driggers. I don't know. I guess they spelled it wrong. I'll put the correct spelling if I need to, but.
So what exactly happened on May 2nd? You said that there were some things that were incorrect. What was incorrect?
When I came home, we were both upset at each other. We did have words back and forth. It didn't get physical to where he said that he knocked me and my son down. I didn't even have my son. My son was in the house. Me and him were outside having a disagreement. My phone did break. He didn't intentionally break my phone, and I didn't have to lock myself in the bathroom. But
okay. And all right. Thank you. Thank you. Your Honor, my client is 18 years old. He is a native of Atlanta. He is currently unemployed, but he was making a little bit of money doing odd jobs. He is still in high school and will be returning for his senior year. He has a 9-month-old child with Miss Driggers. He does deny the allegations. He also told me that there was a verbal disagreement. However, things never turned physical. My client states that his mom, as well as his sister, were present and were witness to the incidents that took place. And he also confirmed that there have been no other altercations, verbal or otherwise, since that date. Again, this incident happened over 2 months ago. My client is currently residing with Ms. Driggers and their child. They do co-parent, and my client does assist in the care of his child. I would request a signature on bond. And if Your Honor is not so inclined, I would ask that you give him the lowest bond that you're willing to give him in this simple battery case.
Your Honor, if I may briefly, while we don't want to cross-examine the witness, we do want to say that we understand that the witness is recanting. However, the witness did on this particular day tell officers that she was struck by by the defendant. She also called police on this particular day. In addition to that, the defendant did flee the scene. So since May 2nd, he has had an outstanding warrant. So he may be a fugitive for justice, Your Honor. For those reasons, we would ask that you keep the bond at the $3,000 surety bond and stay away from 3144 and no further contact with the victim.
And how old is the child?
The child is 9 months old.
And Mr. Hughley is how old at this point?
He is 18.
Still, well, 18. And he's already on a pretrial bond, correct?
3,500.
How much?
3,500.
Okay. All right, I'm going to order a $4,000 surety bond. And with that surety bond, I'm going to order a stay away from 3144 Martin Luther King Jr. Drive. No further contact with the victim. If there is to be visitation with the child, that be facilitated by a third party so that he won't violate the bond by having any contact with the victim.
Excuse me, ma'am, Judge.
I'm not finished with my ruling.
I'm sorry.
Also, there's to be no drugs, alcohol, weapons, or guns while on bond. And that's going to be the ruling of the court. Yes, ma'am. You had a question about the bond?
Yes, ma'am. Because you said, if there was any, I'm not in fear of him or anything. Like I said, we've had contact. We co-parent now. We're in the same household. We no longer stay at the 3144 address. But you said something about a third party, as far as the visitation for our son. That's kind of hard for us because I'm getting myself together. I have my car. I just got my permit. I'm in the process of getting my car fixed. So there's I don't really have close family that's able to do a third party, or I would rather not do a third party because we've been doing well co-parenting. Even after the situation or whatever happened, we've been doing well co-parenting. And like I said, I'm not in fear of him. So I feel that we should be able to co-parent as we've been doing.
Well, there's been an incident. There's been police involvement, and there's been a case that's been accused and brought against Mr. Hughley. And I do understand you may have been co-parenting after this incident. But I want to make sure that you and your child will be safe. And I know it may be tough, but I want to make sure that there has been the ample cooling off period, or the fact that you and your baby will be safe. So he's already out on a pretrial bond that he's technically violated. So therefore, I'm not going to give him another chance on another signature bond to get out and violate that bond. So he's got the history that he's not showing himself to be credible to the court. So that is why I am ordering the $4,000 surety bond, and to give it a break and he stay away from you right now. He is to be 200 yards away from you. He did not contact you by any means, cell phone, email, social media. And I would order for him to take some anger management classes, but I won't order it today. That may be further down the road. And just want to make sure that for the future, you will be safe. So since you don't reside on the MLK, I guess there's no reason to have a stay away there. So what will be checked on this bond order will be the provisions where he needs to stay away from you. And those are pretty strict when you read the bond. And that if you're going to allow him to see the child, you're going to have to find a friend, neighbor, relative, or someone who can do that exchange, because if he violates the bond or he's found there with you, he will be returned to the Fulton County Jail.
Okay.
And that would be on a bond revocation because he's violated the terms again. So, use this time to reflect and cool off, get some help and counseling, and hopefully going forward in the future, it will be better. His attorney will know how to file for a bond modification if that is necessary in the future, okay? All right, thank you.
Thank you, Your Honor. This incident did occur over 2 months ago. Given my client's young age, is there any way you'd be willing to reduce his surety bond from the $4,000? He states that his mother is also experiencing financial hardships. So it's very unlikely that he'll have any assistance in being able to bond out. And that's a fairly high bond for a simple battery that occurred 2 months ago.
Well, it occurred 2 months ago, and then he's been on the run ever since, right?
I don't know about being on the run. He left he left the home. There is no requirement for him to stay. And I'm not sure whether or not he knew that he had a warrant, but I'm not sure that on the run will be an accurate description.
For the same reasons, I think arguing, hold on, Ms. Driggers. For the same reasons, I think arguing that something has happened 2 months ago is as easily disputable and not really relevant in this context. With domestic violence cases, women often call in crisis. And if someone is not arrested on the scene because they flee, it is often a delayed arrest. So saying that this isn't a big deal and it happened so long ago is kind of moot in this situation specifically. We don't know what happened in the time period, but what we have heard from this victim is that they have continued to have contact. They have moved to a new residence together, and she has now gone from being in crisis and asking for help from police to saying, we want to continue to co-parent together. So something has obviously changed, and that's something we would characterize as intimidation and continued domestic violence in a cycle.
There has been no evidence that there's been any intimidation or anything like that from my client perpetrated upon Ms. Driggers. Someone leaving an escalating situation is not necessarily evidence of fleeing, and there was no evidence presented that he fled. And I never said that this situation or domestic violence is not a big deal. I was just pointing out the fact that this did happen 2 months ago. They have continued to have contact and communication. There have been no other issues. He's very young and he does not have the familial support to help him bond out.
Well, the problem is pretrial. Are you revoking the $3,500 bond?
What you say, Judge?
Are you revoking the $3,500 bond?
Yes.
Okay, so he's gonna have other issues, and I just want to make sure he understands how to conduct himself and how to be a good parent and a good significant other to the mother and respectful of her. His history alarms me, and I'm not going to change my ruling. The only thing I will change is to stay away if they don't reside at that location anymore. But I don't want him to have any further contact right now to make sure that they are going to be safe. Next case, Deputy.
Number 8, Mr. Jackson.
Okay. Theodore Smolinski, 23 CR 004401E, charged at 1 count of battery. Pretrial.
This is 4th arrest. Last was on the 3rd of this month out of Gwinnett. Criminal damage to property. Hold on. Okay, that's what the bond assessment stated. He's on probation for criminal damage to property. Disposition date was 2020. They gave him 2 years to serve, 10 years probation for that. And the previous arrest was 1998. Go back. That's it.
Okay. State.
Yes, Your Honor. So this incident occurred yesterday at 1717 Central Villa Drive. And this is where officers arrived and they saw Mr. Billy Bromell sitting on the kitchen floor with blood on his shirt and blood on his face. And officers spoke with Mr. Bromell, who stated that the defendant gave him a key to his apartment, to the defendant's apartment, so that he could look over it as the defendant would be away for some time. And Mr. Bromell told officers that the defendant told him he could stay. And then on yesterday, the defendant came home and he saw Mr. Bromell sitting in his residence. And so the defendant asked him, "What are you doing here? You have to get the F on." And then Mr. Bromell, he stood up, and as he got up, the defendant pepper sprayed him, and then he punched him several times. Mr. Bromell said that after being pepper sprayed, he couldn't see for about 4 or 5 minutes. And so then he walked to the kitchen, and that's where the defendant told him he needed to sit down. And so that's Mr. Bromell's account of the incident. And so we were able to speak to him today, and he let us know that they've been friends for about a year and that he's been staying at the residence for about 3 or 4 months. Mr. Bromell confirmed the events that were listed in the warrant, and he stated that he had to go to the hospital after being pepper sprayed. He let us know that his eyes are still burning and they're still red and he was having difficulty sleeping last night from being pepper sprayed and attacked by the defendant, Your Honor. So for all of these reasons, the state's recommendation is a $3,000 surety bond. We're asking for a 1-day anger awareness course, no further contact with Mr. Bromell. And if Mr. Bromell is going to still be at their residence, we'll be asking for a stay away at 1717 Central Villa Drive. And I believe Mr. Bromell's on Zoom, so I would like to sound for him.
All right, Mr. Bromell. Mr. Bromell.
Mr. Bromell, you have to mute yourself.
Can you hear me?
Now we can. Do you
Thank
wish
you
to
for
address,
having me.
right, do you wish to address the court today?
Yes, ma'am.
All right, raise
Oh,
your right hand so I can swear you in first.
okay.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes, Your
All
Honor.
right. Are you in fear of Mr. Smolinski?
And fear? No, I'm not. I'm not. And I think he's and I asked him once before about being angry at every little small thing that goes on. I mean, putting the wash and dry and stuff like that together, which I purchased. I made the purchase on it, and it's sent resident. And it just kept going on because I told him, I said, man, I don't mind you getting on me, but I said, I don't mind you getting on me, but I'm just like a brother to you. And I just don't want you to think because I give you permission, you can talk to me like an animal. And that was what started taking place. And then, everything started escalating. So, but I spoke with Miss Tanya at the office. And I'm waiting on my birth certificate and all so I can be on the lease. I asked to be on the lease, and that's been prolonged because I want my birth certificate so I can get on it. But he told me when I got there that was okay, that you can stay and look over the residence while I'm gone. And as soon as they started seeing what was going on, they was like, well, you have a tenant in your place. And I went there kindly and told them, I said, yes. I said, well, I'm waiting on my birth certificate and all, so I will be able to stay there and, and watch over his place. And I don't mind giving him extra money for staying because he don't stay there, but he's not even there 90, 98, 99% there. He comes home every 2 or 3 weeks.
Okay,
So
1 second. I'm sorry, Your Honor, Mr. Bromell. Just 1 second. Just quickly, Mr. Bromell, are you staying at that residence currently?
yes, I am.
And let me ask, do you want contact with Mr. Bromell? I mean, not Mr. Bromell, but the defendant in this case?
Sure.
You wouldn't mind
I
contact?
don't have no problem with that. I mean, as long as he be able to, deal with me as a man and talk to me as a man so I can talk to him because, that's the way I want life is to be.
Okay. All right. And I just would like to confirm on yesterday, the defendant did pepper spray you and punch you.
That is correct.
Okay. Thank you, Your Honor. Thank you, Mr. Bromell. Judge Missy.
Yes, ma'am.
All right. PD Kim?
Yes, Your Honor. Your Honor, the story is not like that. House is actually the place belongs to my client, Your Honor, and he has every right to protect his place. He asked Mr. Bromwell to leave the premises, and there was no requirement for eviction to be filed because it was not more than 30 days. He was there for a few days and he politely asked him to leave. Mr. Bromell would not leave. And my client changed the lock for the apartment to make sure he doesn't come back. And however, Mr. Billy was still in the premises. That was really shocking to my client, and he was scared. He was defending himself. Your Honor, it is his right, my client's right, to protect himself and his place at his place. But for any kind of invasion, Your Honor, he was doing self-defense. My client is 52 years old, and he has children are all older. He's working as a truck driver for Western Express. He graduated from high school in Roswell. Your Honor, he also served in the military as a veteran from 1992 to 1996, Marine Corps. He's 40% disabled, and yet he's still working. He's been here in Georgia for 39 years. He deserves to be at his home with peace. We would like to request for signature on bond, and we are just kind of shocked why Billy Bromell was not arrested for invading into somebody else's house without permission. Thank you, Your Honor.
And so, Mr. Bromell, you do not want contact, correct?
I said, yes, he can have contact with me.
Okay.
Certainly. I mean, I'm not going to turn my back, but, you know, everything was, you know, was said what I said, that I was there for the amount of time that I was there, and there wasn't nothing going on until up to the last, you know, week or two, and then things started to fall apart. And he helped me out. He actually helped me out to do my to get my birth certificate online.
So
probably have my information, all my information in his phone on that terms, but I'm just telling you just how it is. You know,
I appreciate that.
About it.
I appreciate that. Who lives at
And,
the 1717 Central Villa?
Ma'am?
Whose address is the 1717 Central Villa?
It's Ted's. It's Theodore. That's his name. And you know, and I was looking forward to getting my birth certificate because I already filled out the information to give to the Atlanta Housing to be there. And I spoke to the Atlanta Housing, and they told me it was up to. It's not up to the where the Atlanta Housing said, hey, we don't have anything to do with the lease. We don't have anything to do with the lease. Okay. And he said it's up to the managers at the apartment complex to, you know, and it's up to Ted, whatever he wants to do. But he wants me to get the lease. I mean, he wants me to get the lease signed so, you know, somebody can look after his place. And now he's just changed his mind. He's changed his mind on it. And I don't understand that. I don't understand it. You know?
May I add, this is the defendant's residence. And however, Mr. Bromell has been staying here, and it's, I guess, how do I say, not in great taste to put the victim out of somewhere that he's been victimized at. So I guess if an escort, the defendant could go back to his home if a police could determine that Mr. Bromell is no longer in that residence for however long as it takes, or, you know, as the proceedings go on in this case, Your Honor.
All right. Well, I have two concerns. If I don't do a stay away and Mr. Bromell goes back, then we don't want the police to be called again.
Right.
We have to make sure the victim is going to be safe, which is Mr. Bromell, wherever he resides, and just trying to sort that out and do what will hopefully be best for both of these roommates, I guess, for lack of a better word.
Yes, Your Honor, it's such a short notice for this to take place, and right now I don't have a place until I get my birth certificate, and then I can go out on my own. I'd be more than welcome to do that. Yeah.
And I know that PD Kim, you may not want Mr. Smolinski to say anything, but
if you're a man about it, if he's going to be a man about it, I can be a man about it, and we can talk it over and work things out. I don't have no problem.
That's kind of not how it goes at this point, right?
Right, because I'm at age right now. I'm 65 years old, and so I'm trying to, do all I can. But I just started the services that I have, and I just got a new client, which calls Touche's over, and I got it. I can do that, and plus I got a contract with the Malones, so that's going to start next week. So I'll be in good shape. I can be in good shape and do whatever I want to do.
So are you planning then to move out in a couple of weeks?
Yes, ma'am. Try to get that. Yeah. At least a
Okay.
month. Give me a month and I can operate. But I'm not gonna say nothing. I'm not gonna argue with him. And certainly he shouldn't argue with me about, because this takes away from me. And surely it took away from him. Because we could be a man about it. Just say, hey, all right, let's go to the office. Let's talk to him and see what could take place or what can transpire with this. So we both won't be in the middle of it. They can say, hey, Mr. Bromell, we understand that you're waiting on your lease. I mean, not the lease, well, wait to get your lease and waiting on your birth certificate to come from North Carolina, and we're going to work with you. And that would have summed everything up instead of, trying to take matters in your own hands. Sometimes you can't do that. You can't take matters in your own hands. There's laws be made. There's laws that's impact stuff like this.
Right.
Honor, this situation is really weird because my client has to be kicked out from his own place. They were not roommates. And I mean, my client is the leaseholder, Your Honor. This is place. He's the one who has to be protected.
Well, I wouldn't say the leaseholder in a situation of battery or some type of violence needs to be protected. Our first concern is to the victim to be protected, as ASG Bickerstaff has stated. And I was going to put a date on there, as far as the time frame that Mr. Bromell could be there. Bromell, I'm sorry, I keep putting an I on the end. Pardon me.
That's okay, Young. That's okay.
Mr. Bromell could be there. I don't normally get that involved intrinsic in it, so that again, we don't put people in situations that are not going to be positive for them going forward. But I understand Mr. Bromell may need somewhere to live because he's been there. And I definitely
could you speak up a little bit, please?
Okay, I am trying to think it through. Don't have a lot of time. I'm going to do a $3,000 signature bond.
You're gonna do what now?
I'm going to order a $3,000 signature bond. Gonna order that signature bond through the jail for Mr. Smolinski. As far as the contact between the two of you, I'm going to order no further violent contact. But this has not been 24 hours. There needs to be a cooling down period. Need to make sure that this incident is finished and over, and usually it's not so fast within less than 24 hours. We don't want the police coming back. We don't want any more incidents of violence, and we don't want you, Mr. Bromell, as the victim to undergo any more incidents. So what I'm going to do is you asked for some time so that you could do this. And I know, again, Mr. Smolinski is not going to be happy with it. But I'm going to say that you would be there a couple of weeks. Today is the 14th.
I think he left, didn't he?
No.
He's still there?
Yes.
Where'd he go?
Just briefly.
Are his cameras off?
I don't see him on the Zoom no more.
No, I don't either.
So, okay.
It dropped. I was going to give a date.
Well, he gone.
Yeah, his phone might have died.
I would just like to object, Your Honor, to the $3,000 signature bond through the jail and the no further violent contact, specifically because this incident just happened yesterday. And Mr. Bromell complained of not being able to sleep. And his eyes were still burning. He had to go to he was hospitalized from being pepper sprayed yesterday. Although Mr. Bromell saying that he doesn't mind having contact with him, but obviously tempers are flared where the defendant felt the need to punch him and pepper spray him, opposed to putting in an eviction notice to get Mr. Bromell out of his house. Instead, he decided to assault him. So the state would stand firm on the $3,000 surety bond, along with the no further contact with Mr. Bromell right now. I know it's not ideal to kick the defendant out of his residence, but it is unfair to kick the victim out of somewhere he has been assaulted.
He was not assaulted. My client was defending himself from invasion to his own private place. Somebody came, unlocked the door, and yeah, he was the one who attacked my client first. My client wanted to defend himself.
Well,
we have no objection to no further contact.
Right. Let's do that. No further contact with the victim.
And I would like to request for a one-time law enforcement officer to verify that Mr. Bromell is not there. Then my client should be able to go back to his own place, Your Honor.
Right. And that may be in a couple of weeks. It doesn't sound like Mr. Bromell is able to leave tomorrow. So, Mr. Smolinski, I'm going to order a stay away from the residence until you return with law enforcement to ensure that Mr. Bromell has moved out of the residence before you're able to stay there. Okay? That's the only way I can kind of go through the middle of this. And it may be 2 weeks, it may be 3 weeks. So hopefully when law enforcement go, and I would say give it at least a week or so, they will be able to speak to Mr. Bromell and determine what date he will be moving out so that you will know what date you need to return with law enforcement to do that investigation or to do the sweep of the home to determine whether Mr. Bromell lives there. So when you make bond, I'm going to ask you to at least give it a week before you go there first and let the officers know you may have to go back a second time. And if you wait a week, that would be the 21st, 22nd, give or take. But you've got to go back with law enforcement to begin with and not take matters into your own hands. And again, that's no further contact and no drugs, alcohol, weapons, or guns while on bond. Is my ruling clear?
So I'm in town every 2 to 3 weeks. I will drive over the road with semi trucks. I just came in town yesterday, noticed his stuff is still in my place, which I told him 2 weeks ago. He had some things in my spare bedroom. He said he was just doing some laundry. I said, this stuff needs to go. I had a notification on my door because he keeps going in and out of my apartment more than I expected him to. They're supposed to just be doing maintenance issues and making sure they were fixed by the maintenance people of the complex. So he decided, when I got back yesterday, my spare bedroom is full of clothes in garbage bags and everything else all spread out through this bedroom. And I'm like, why is your stuff in my apartment? I never gave you permission to be in here. This whole thing of him doing this for months in my place is a misnomer. He is misspoken and is not correct. I am in town till Monday afternoon. I need to get clothes to get packed to go back on the road for 2 to 3 weeks. And if I need to go, I'll go back on the road tonight or tomorrow, whenever I bail out. But I need to get my clothes.
Okay.
And my hygiene and everything else that I need for my trip.
Okay. So what we'll do is we'll allow that one-time law enforcement escort for you to go back to the property to retrieve your ID, your personal belongings. That's the one-time escort. And then in a couple of weeks, you can arrange for a second law enforcement escort to determine if Mr. Bromell has moved out, and then you can occupy the residence. But they have to be able to.
That's what I waited on this last time I was out of town to see if he got his stuff out, but no, he put more stuff in.
Right. Well,
so I need to know when he can leave.
Yeah.
I mean, I guess I have a question just briefly. This sounds a little complicated and it sounds like a mixture of some civil and criminal situations, but it sounds like at this point, there's a dispute between whether or not the victim was allowed to stay and remain in the location.
Mm-hmm. Sounds
Um,
like it.
And then assault occurred, or an altercation occurred, since Ms. Kim doesn't like that word in this situation. I believe it would be appropriate to explain to the defendant that he needs to maybe go through the eviction process. It doesn't
Certainly.
appear that the dispute about the right to be in the location is going to be resolved at this point. And so the state is concerned that should the defendant receive and make a bond, the continued issue about our victim remaining on the property is going to continue to escalate.
Right. I am too. I am too.
Annalise,
Yeah.
not receiving any mail at my location.
Sir,
I
hold
just-
on a moment, please. You're represented?
Yes.
Strongly recommend you to stay silent.
Yeah, that doesn't impress me. I'm not concerned about that. It's just the physical presence. Since I know that Mr. Smolinski, as he stated, can get on the road and can be gone, I think that's going to be the best thing, is to stay away for the defendant, to allow the victim time to move and get his things away from that property. I don't know how long that's going to take. I am interested, in making sure that the victim is safe and can live there peacefully while he is, as he says, working to get money to move. So I'm going to still order the $3,000 signature bond through the jail, stay away from 1717 Central Villa Drive until the victim, with your police escort, has determined that he's moved. You will get that one-time initial escort to go back and get all your personal belongings. And then in a couple of weeks, you can go back with the officer again to determine if he's moved before you can stay there.
So why, how do I determine that before I have to show up with an officer to determine if he's moved or not?
Right.
So how does he have all these rights to my place? I don't get it. It doesn't make sense to me. One bit.
Well,
If I give a key to someone, if I had a fish and I give a key to someone to feed my fish every 2 days, they have the right to move in all their junk to my bedroom, and all of a sudden they're a squatter in my place and they're able to live there?
That happens a lot these days.
I
And
bet it
there's a
does.
civil
Because it's
process.
going on right now.
There's a civil process to go through for that, but it does happen quite often. So you have to be careful of that. Unfortunately, that's all I can say to that, because I'm not giving you advice and I don't represent you. But as a judge, we hear a lot, and we hear a lot of things that happen. So you have to be careful. That's all I can say to you. But it is not unusual at all, and it's not unique to you. So that is what the ruling of the court is to stay away, one-time escort to go back, and no further, and I don't remember, did we say no further contact or no further violent contact? I think PD Kim agreed to no further contact. Okay, no further contact. And no drugs, alcohol, weapons, or guns while on bond. You'll probably have to look at some civil avenues once you're out, as the ASG has stated. All right. Next case.